Good morning, everybody. Happy Tuesday. We have an amazing show for everybody today. Another solo show, but I got plenty of guests, so don't worry. You don't just have to stare at my ugly mug. We're starting a little bit late today, as I said yesterday, to accommodate RFK Jr. We're going to have an exclusive interview here and get his reaction to the debate. Very interested in that. We are going to start off with an amazing debate between Bradley Moss and Will Chamberlain. They're both lawyers and experts opposing views on the Supreme Court decision regarding presidential immunity. I will then break down some of the latest news regarding Joe Biden, his debate performance, the Democratic establishment, and their reactions. We're also going to talk about Boeing getting criminally charged with fraud and what the fallout from that will be. So it's going to be a fantastic show. Thank you to everybody, premium subscribers who have been supporting us at breakingpoints.com, expanding our coverage. Don't forget, we are going to be down on the ground in Chicago at the DNC. So if you want to help support our work for that, as you said, become a premium subscriber and get all of those benefits. But with that, I've got two great guests standing by. Let's go ahead and bring them in. We've got Bradley Moss, he's a national security lawyer, and we've got Will Chamberlain. Both of these gentlemen have appeared on the show before. Will is the senior counsel at the Article 3 Project, and we're very excited to be joined by both of you because there's been a lot of discussion here about the Supreme Court decision regarding presidential immunity. I'm going to go ahead and put this up there on the screen and read a little bit from this, and I want to get both of your reactions. So the Supreme Court has ruled that the ex-presidents have, quote, broad immunity, but the broad immunity applies only to so-called official acts. The secondary effect of this is going to dramatically decrease the chance of a pre-election Donald Trump trial. Let's go to the next slide, please, so I can read a little bit from the decision itself. The decision maintains that from the conservative majority that has returned it to the trial court to determine what is then left of the special counsel Jack Smith indictment. As I said before, it applies to official acts of the presidency. Reading here directly from John Roberts. Under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within this conclusive and preclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all of his official acts. There is no immunity for unofficial acts. Brad, I want to go ahead and start with you. There has been a lot of discussion about Justice Sotomayor's dissent in particular, in which she claims that Donald Trump, under this authority, would be allowed to send SEAL Team 6, as posed in the hypothetical questioning, to assassinate his political opponent. What is your reading of the decision? What did you make of the dissent? Do you think that that's true?
Well, Justice Sotomayor is not too far off in terms of how the majority opinion has structured this. So to be clear, they basically created three buckets. One is that absolute immunity that goes for everything that's within the exclusive authority of the executive branch. Think about it. That's running the Justice Department, which is why they completely knocked out a couple of the charges against Donald Trump in the election interference case. That's controlling the military. He's the commander-in-chief. He has exclusive control of how the military operates. There's any number of things that an incumbent president can do with those authorities that, according to this majority opinion, are absolutely immune. But then let's extend it a little further. Let's say that there's a dispute over whether or not it's within the core. Let's say, but it's still within the outer perimeters of a president's authority to, say, declare someone a national security threat and have the military seize them, put them in Gitmo, and silence them. The court will still treat that as presumptively immune, and they will not allow in any evidence of the president's intent or any evidence that came from acts that are otherwise subject to absolute immunity, such as coordinating with Justice Department lawyers like, say, Jeffrey Clark, or coordinating with military officials such as the Secretary of Defense or the commander of the commander of the Joint Chiefs. Any of those things would be evidence that would be excluded, and the government would still, the prosecutor would still have to somehow demonstrate through the remaining evidence that the presumptive immunity can be outweighed. It would not infringe on executive authorities. What could be more principal to the executive authority than identifying national security threats, taking action to secure the public? This is a recipe for disaster with a president who chooses to abuse these authorities.
Will, can we go ahead and get your rebuttal, please?
That's been the status quo for 20 years. President Obama assassinated the son of the preacher al-Awlaki and hasn't been prosecuted. Really, that's honestly the settled understanding of our country. And I think the really simple way to understand the Supreme Court's decision is not some broad expansion of presidential immunity beyond what was already understood, but rather just reifying the kind of common understanding. Nobody prosecuted President Obama. Nobody prosecuted President Bush for all the abuses of the intelligence services under his administration. And so I don't think that, I think people are wildly overblowing this. The Supreme Court's opinion is actually substantially more modest than I think it should have been, honestly. And that a lot of, and it's certainly not something that's going to lead to this parade of horribles that people are expecting.
Well, can I respond to that?
Yeah, you can go ahead and respond to that.
Yeah, because I know these examples get brought up every time, the Bush and the Obama examples. So let's be clear on something. With the Bush examples, there actually were inquiries conducted led by none other than John Durham at the time, who is the U.S. attorney out there in Connecticut, to look into whether or not there should be potential criminal charges brought. The fact that they did not does not mean they could not. The Justice Department's opinion has never been in the past that a former president can't be prosecuted. That was never in any OLC opinion. It was always just about incumbent presidents. The courts had never concluded this prior to this decision. As for President Obama, there was no indication that anyone had ever concluded he was immune if, in fact, the next president, such as Donald Trump, had chosen to bring a case against him. There was no argument ever outlined in any Justice Department documentation saying he was absolutely immune. Would he have presumptive immunity according to this decision? Yeah. Could it be overturned? Absolutely.
Well, I want to stick actually within a conservative framework and kind of, because I have seen at least some more libertarian-minded folks object to this on the grounds of executive power. Can you just give us kind of a view, as you said, into the decision itself and where it should be? I mean, hypothetically, should a president, again, not to necessarily stick with the Sotomayor framework, but the media has given this, and so we should have to play within it. Within that framework, should that be something that should be hypothetically up then to the justice system or to the next administration to be able to bring charges against a former president, or no? In a genuine conceptual universe?
I mean, it should be extraordinarily challenging. And I think the reason is precisely what the majority identified, which is this circumstance where presidents routinely prosecute their predecessors for acts that they took while they're in office. Because, I mean, you think about how broad and how vague the statute that President Trump is being prosecuted under, conspiracy against rights, conspiracy against the United States. These are very broad, and essentially it's like hindering the functioning of government is the crime. Well, I mean, presidents do things all the time that push on the edges of the law. I mean, I could name 5 off the top of my head that Biden has done. If they aren't immune from prosecution for those, then it's really going to hinder the functioning of the executive, who's constantly going to be thinking about the consequences of their actions. Even simple presidential actions from a future political opponent who might hate them. And I mean, the idea that was the world we were headed to in the absence of this ruling, because I guarantee you, I mean, President Biden should be breathing a sigh of relief. He would have been prosecuted for any number of distinct official acts that he took while in office, paroling hundreds of thousands of illegal immigrants into the country well beyond his parole authority, attempting to circumvent the Supreme Court's decision in the student loan issues for his own political purposes. All these things would have been prosecuted in a world where presidents weren't immune for their official acts. President Obama should be breathing a sigh of relief, because we certainly would have indicted him for murder on day one in January when President Trump takes office. So I think it's a good thing for the country that they ended this sort of potential for this tit for tat escalation and the destruction of the executive branch. And, you go all the way back to, why do we have the Constitution? To replace the Articles of Confederation, which didn't have a functioning executive capable of taking action with dispatch. The entire, the thrust of the Federalist Papers is about the importance of an energetic executive. And that's what the Supreme Court ruling preserves.
Brad, I want to give you a chance to respond to that.
Yeah, I'm trying really hard to laugh. Yeah, let me tell you, Democratic presidents are just so relieved. They were so terrified at the idea that they were going to be indicted any day now. Every president has known they are not above the law. Every other president has come and gone knowing they were not above the law, that if in fact they had committed crimes, there was not this complete immunity that could shield them forever. And it didn't happen. The reason Donald Trump got indicted is because Donald Trump couldn't accept he lost the election, and Donald Trump conspired to prevent the lawful certification of electoral votes. He conspired to put up fake electors. That's why he got indicted in the D.C. case. No other president has been indicted for murder ever, and it's a laughable excuse that, they're relieved now. Give me a break.
Okay, well, let's stick with that, though, because the January 6th element of this is actually quite important. Will, I'll let you lay out a little bit of this, because as I understand it, there is a parsing in the Jack Smith charges, specifically between the so-called official acts as president and instructions to the acting attorney general versus the so-called false elector scheme, which would perhaps fall into a campaign bucket. What is your view of that within the decision, Will? Lay some of that out, and Brad, I'll let you do it as well.
I mean, yeah, the decision obviously distinguishes between the official acts of a president and his private acts. And I've read the opinion, but I need to look at it again to confirm. But I'm pretty confident they suggested that the fake electors, or essentially the electors issue, would probably all be private acts. I don't remember if they firmly held that, but it's something in that neighborhood. Certainly, yeah, his discussions with Jeff Clark and the Department of Justice, I think they said, would be absolutely immune, because he has the duty to take care that the laws be faithfully executed and the absolute right to be discussing with the Department of Justice how it's going about its affairs. That said, I think, people are saying, I think the big thing that I would disagree with in terms of what Brad Moss is saying is that Trump did this unique, horrible thing. You go back to 2016, we had objections from the Democrats, including people like Jamie Raskin, to the presidential electors. Go back to 1960, we had the exact same mechanism used in the case of the Hawaii electors, where the election was extremely close, and you had alternate electors who met to certify the votes, even though they weren't the actual electors. The idea being that they wanted to preserve their legal challenge. So the norm breaking here is not on the part of Trump going and trying to do something, to challenge the elector scheme in this way. The norm breaking is the attempt to be the first administration to ever prosecute a former president. Throughout the Supreme Court opinion, it discusses why is this unique? Well, they decided to go after President Trump. They decided to launch an unprecedented lawfare campaign against him, indicting him in four jurisdictions in 4 states in a little less than 4 months on different criminal activity. Alleged criminal activity, obviously. And the point being that that's why this is unprecedented, and that's why the Supreme Court needed to put a stop to it now. Otherwise, because President Trump's going to beat Joe Biden. Joe Biden looked terrible at that last debate. He's going to lose by 5 or 6. And I'm really glad that the Supreme Court decided to put a stop to this now, because we would have tit for tat until the end of time. It would be very, very bad for the country. Ultimately,
Brad, you want to give a response?
Rule differently.
Oh, sure. Here's the difference with 2016. Here's the difference with 1960. Here's the difference with 2000. It wasn't the incumbent president who was the loser in the election trying to lead these efforts. To give that some context, to go back to 2016, when there were objections, like there always are at electoral certification. Imagine if between the date that Hillary conceded to Donald Trump and the certification of the votes in January 6, 2017, if President Obama, using his official authorities, had been telling the DOJ to try to put out any claims, any fraudulent claims of fraud, to put out any allegations they could to get state electors to reverse electoral certifications, to then go to a whole huge rally the day of the certification, tell them, we're going to march on the Capitol. You have to be strong. And then say, I'm going to march with you. And then that whole group breaks into the Capitol and tries to murder the incumbent vice president and members of Congress. Imagine if that had happened. They're cool with that. They're cool with Joe Biden and Kamala Harris doing that if Joe Biden loses on January 6, 2025. They're saying, yeah, you can do that and you have total immunity. Go ahead, have fun. Let's see what happens.
I'll give you a chance to respond.
Just imagine a world where a president had, after their preferred candidate had lost an election, had decided to, with his colleagues, create an entire narrative that was totally false about the billionaire real estate magnate turned president-elect actually being an agent of a foreign country. Just imagine that. That could never possibly happen. And
I got to be honest, Brad, that's the first thing that came to my mind.
A coordinated conspiracy with the FBI, James Comey, all of them, to completely BS a massive nonsense Russiagate narrative that ultimately led to 3 years of the future presidency being ruined and mired in absolute nonsense lawfare. The funny thing is this lawfare campaign has been going on for 9 years now, effectively. It started almost all the way back in 2015. So, the idea that basically, my point being that it's like the idea that a president whose party just lost an election wouldn't actually, that this is some novel idea that they would be very upset about it and trying to use every lawful lever at their disposal to try and undermine the next president. Yeah, we saw that in 2016. That's exactly what the Democrats did to the Republicans. They're the first ones who really refused to accept the legitimacy of the election.
All right, Brad, go ahead.
So I don't
Let's
really
give him
have
a full
any
chance to
time
respond
for the idea that this is some unique thing in American history. 2016 was as bad or worse.
Let's give Brad a full chance to respond.
The wonderful the love affair they have with the idea that the whole Russia investigation was just a hoax. Even the Senate Republican report that came out in 2019 said the Trump campaign wittingly used Russian disinformation. There was a counterintelligence threat by the fact that the campaign manager was giving polling data to his Russian oligarch benefactor. The campaign manager got convicted and went to prison. The deputy campaign manager pled guilty. Multiple staffers pled guilty. It was the most ridiculous idea that there was nothing to this. Could you prove a conspiracy to commit a crime for Donald Trump? No, and I said the day after the Mueller report came out, they never proved that in the end. It was two ships passing in the night. But the idea there was not a counterintelligence threat, that Donald Trump's campaign didn't wittingly use what they had been warned was Russian counterintelligence disinformation is ridiculous. It's in the Mueller report. It's in the Senate Republican report. Don't take me. Report takes Senate Republicans.
Okay, last word on Russiagate before we move on to the trial. Go ahead, Will.
I mean, the entire investigation was predicated on the Steele report, which accused the president of urinating on Russian prostitutes. And that was all false, all nonsense, none of it corroborated, all ridiculous. The idea that you're still, 9 years later defending this nonsense, Bradley, is ridiculous.
All right, so let's then stick with the trial itself. I think we can all agree that the trial is going to be delayed. I want to give Brad, you can give us perhaps a rundown on why and what that mechanism looks like as some of this works its way through the courts. Go ahead.
Oh, yeah, I mean, the cases are not going to happen at this point before the trial, before the election. There's just no chance. That's never going to happen. So the case goes back to the district court, to Judge Shukin in D.C. Biggest question is, does Jack Smith's move to sort of gut and narrow down the indictment to just the fake elector scheme? I know Will had brought that up. The majority opinion didn't actually clarify one way or the other what they thought of it. It came up in oral arguments a lot. That'll certainly be an issue of dispute of whether or not that was a purely personal act. Trump's lawyers were on CNN last night with Kate Collins saying they view organizing the slate of false electors as an official presidential act. That'll be interesting to see how that one plays out. But that has to be now disputed in pretrial motions. No matter what the ruling, either side can appeal it because it implicates immunity. That'll take at least a year to flesh out. But also, the other cases are all stuck on hold now. Florida, I mean, even it was already delayed anyways because of the classified elements of that case. But now that immunity fight has to be drawn out. And think about this. This is the lovely thing we got from Trump's arguments in Florida in the documents case. According to Donald Trump, on the last day of his presidency, Joe Biden can literally walk out of the White House carrying boxes that say top secret SCI information, flip off the media and say, by virtue of the fact that I'm still president for the next 20 minutes, I am now declaring all this personal records and you can't touch me.
Go ahead, Will.
On what point?
I'm just curious. I'm curious, well, A, if you want to respond to that, but also in terms of the legitimacy of the current cases that stand. As I understand it, the Trump campaign and Trump's lawyers are moving to dismiss both the Georgia indictment against him, delay the Florida case, but perhaps most importantly is to delay the July 11 sentencing that is currently awaiting for the New York trial, because I believe that the original indictment that was presented against Trump actually did occur while he was the sitting president of the United States, as stated in the facts by Alvin Bragg. So go ahead.
Yeah, I mean, I can see why they try to do that. I think the primary impact of this will obviously be felt on the J6 indictment and the Georgia indictment. Both of those really directly deal with the president's actions while he was president. The classified information is a little bit more interesting because it sort of touches on right when he started and stopped being president. And so I think that is a little bit less, it could go either way. I don't really, it's hard to see how that would happen. I think that case is probably going to get resolved actually at the outset on the idea that Jack Smith wasn't a legitimate, the special counsel appointment was improper. And so the prosecution's improper. And yet New York, I think that's just an attempt to delay the sentencing.
Got it. All right. Well, I'm going to end in a tactic that Crystal always does, which is asking each to steelman necessarily the other. So, Brad, give us the steelman case as to why the Sotomayor dissent and the Democratic response, including the president declaring that there is now a king in office if needed. Why is that incorrect in the American system?
The reason it would be incorrect is the simple sense that the separation of powers, the existence of Congress, the existence of the judicial branch and their ability to oversee how the executive performs its duties still remains in place. The ability of states to still govern themselves in terms of how their personnel are handled, those things still exist. So to the extent that Justice Sotomayor went too far, it's the idea that a president is still subject to a 4-year term. It's the idea that a president is still subject to all the constitutional amendments, and the restrictions that exist based off Article 1 and Article 3 are still in place.
Will, give us the counter case. In a conceptual world, why would this ruling necessarily be bad in the American system? Take Trump out of it. What could be the worst case scenario?
I don't think the Sotomayor dissent has any merit at all. So, but I will say I think Barrett's concurrence makes a reasonable point, which is the sort of, I think, the most interesting and contestable part of the majority opinion is about whether or not official acts, even if you're immune from them, can be used as evidence and how exactly that would work. I think there's an interesting debate between majority opinion and the concurrence kind of about whether or not bribery prosecutions would ultimately work. I think so. That's I think the strongest point against the majority opinion, but I found Sotomayor's dissent. I mean, honestly, I don't think it's steelmanable. I think it's just one of the weakest pieces of legal writing I've read in quite a while.
Still a good point there on the bribery statute and more. Gentlemen, we'll have links to your Twitters, both in our X's, I apologize, in the description of this video. And I think people will really get a lot out of this. I actually learned a lot, so thank you both. We appreciate you.
Absolutely.
Hey, if you like that video, hit the like button or leave a comment below. It really helps get the show to more people.
And if you'd like to get the full show ad-free and in your inbox every morning, you can sign up at breakingpoints.com.
That's right. Get the full show, help support the future of independent media at breakingpoints.com.